Okay, so let's get started. So again, my name is Deirdre Baker, and I am one of the attorneys with the Makovsky Law Group. Our office is located in Garden City. We're elder law attorneys, so we focus primarily on the areas of trust and estates, disability planning, asset protection planning. We handle Medicaid applications, and we also do estate administration and probate proceedings. I had emailed out some handouts yesterday that go into a bit more detail for some of the topics we're going to be covering. And if you didn't get a copy, or if you have any questions that don't get addressed here, please feel free to email me at the email address right here at the bottom of the screen. And if anyone's having any issues hearing me or seeing the slides, please just put that in the chat function so I can make sure everyone's getting the most out of the presentation. So let's get started. Today we're going to be talking about how you leave assets to your heirs. And we're going to be discussing in more detail the 4 general ways that property passes to your loved ones at your death. The first way that you pass property or assets to your loved ones is through intestacy, and I'll explain what that means, by operation of law, under the terms of a last will and testament, or under the terms of a trust. So we're going to talk about all of these in a bit more detail, and we're going to start with the intestacy. So what is intestacy? Intestacy is basically a fancy way of saying when someone passes away and they don't have a last will and testament, and they own some asset in their name alone when they pass away. Sorry, I don't know why I did that. So essentially, when you die without a will in New York State, the state determines who receives your property and in what percentage. The court will ultimately appoint someone known as an administrator, and the administrator, his or her job basically is to file a petition with the court, file all the other necessary papers, and they're the ones who will collect your assets, open an estate bank account, and ultimately distribute the assets of the estate according to what the court dictates. Here it's a little tricky because the decedent leaves no instructions, leaves nothing behind that would indicate what he or she would have wanted, and makes it a bit more complicated because ultimately the court has the final say-so regarding who is going to be in charge of the estate and in charge of collecting the assets. So here are some of the basic rules for how property is distributed under the rules of intestacy in New York. If a decedent passes away and they leave behind a spouse and children, the spouse will get the first $50,000 off the top of the estate, and anything that's left over will be split equally between the spouse and the decedent's children. If the decedent passes away with a spouse and no children, the spouse will inherit everything. And if the decedent passes away with no spouse but children, the children or the grandchildren will inherit. So a couple of things that I want to mention here is the rules of intestacy focus solely on blood relationships, and they don't take into account the actual life circumstances of either the decedent or their beneficiaries or distributees. So it can get a little complicated if you are estranged from one of your children, if one of your children is a minor or disabled or has creditor issues or is going through a divorce. New York State, unfortunately, doesn't have the authority to do any special planning or instructions once someone's gone and there's no will. So it can get a little complicated if one of your beneficiaries is, for example, getting special services because they're disabled. If they get an inheritance from you because you pass away without a will, that can be pretty disruptive to benefits or services that they have in place. The estate administration under intestacy also gets really complicated when we're not talking about spouse and children, but we're talking about more distant relatives. So, for example, if someone's single and they don't have children, rather than it going to spouse and children, because there are none, instead it goes to either their parents, or if their parents have predeceased, to their siblings. If their siblings have predeceased, it can go to their nieces or nephews, or even great nieces and nephews. And where it gets complicated is that all of these people need to be notified. and the court needs to ensure that all the necessary parties have been served and notified before anything can move forward with the estate. So the more complicated your family tree, the longer you're looking at in terms of an estate administration. And if there's something like a house that needs to be sold or assets that need to be collected, this can really cause a strain on the estate because someone needs to be paying these expenses while you're waiting for the authority to sell property. So that's just something to keep in mind. And we kind of touched on this a little bit, but again, the more remote the beneficiary to the decedent, the more complicated it is, and generally the longer the process will take. And then the longer it takes, it means more attorney's fees. Where it can get particularly complicated is if there's some type of contest or if there's a lack of clarity about who the actual relatives are, and if there's what's known as alleged distributees. So when you're talking about not nieces or nephews, but first cousins and first cousins once removed, it can get complicated because now these individuals have to prove that they're related. And again, just means more attorneys that get involved, the longer the process takes, and the greater the expense to the estate. The second general way that property passes in New York State, or any state really, is by operation of law. So operation of law essentially means that at the death of one person, the asset has a place to go because it meets one of these requirements here. So it's something that either has a joint owner or it has a beneficiary. So these examples on your screen are just a couple of the common assets that you'll see that pass by operation of law. Something like a life insurance policy very often has a way for the owner to designate beneficiaries. So at his or her death, the balance or the benefit will pass automatically to the named beneficiaries. Retirement accounts, something like a 401k or an IRA, is also another common type of account that passes by operation of law if there's a proper planning done. A TOD or transfer on death account or an in trust for account are basically accounts that when you establish the account, you're putting it in trust for the benefit of somebody else. You reserve the right as the owner to make changes to that during your life, but at your passing, whoever you have designated as your beneficiary will automatically inherit that asset. Rather than waiting for the court, as we just described through intestacy, here, the beneficiary simply needs to go to the financial institution, prove that they're the named beneficiary, present a death certificate, and collect the proceeds of the account. Assets that are owned jointly, known as joint tenancy with rights of survivorship, those assets at the death of the first owner will pass automatically to the surviving joint owner. So this is very common when spouses own property together. If you are married and you look at the deed to your home, you may see language that says John Smith and Jane Smith, his wife. That basically means that if John predeceases Jane, Jane won't have to go to court or make any changes to the deed to her property, because the title company or anyone who reviews that deed will know that at John's passing, Jane became the 100% owner of that property, and she has the full authority to sell it or make any changes to the title that she wishes. One note that I would like to make here is it's not uncommon for clients to sometimes put one of their children on their checking account for the purposes of helping them pay their bills if they become sick, or having access to the account after they're gone to pay things like funeral expenses. One thing to note is, even though someone may be on the account jointly with you, you have to make a decision when you're adding that person if you want to make a gift of that account to them, or if you're really just putting them on there for the purposes of convenience. Convenience purposes means you don't really want to make a gift to them. And if you have other children, for example, your intention is for that account to be split evenly amongst your children. But that's something that you should really make clear to your children, to the person you're adding to the account, and to someone that may not be on the account, because this is something that comes up a lot in contested probate or administration proceedings, the treatment of these types of accounts. So if you recognize that one of your children is spending a lot of time helping you and you want to give them some additional gift, that's obviously completely fine, but you probably will avoid a lot of headaches for your children or your beneficiaries down the road if you just make that point very clear to them. So the third topic that we'll be discussing is last will and testament. This is probably the area that most everyone has heard something about. They've either already drafted a will, or they've had to go through the probate process on behalf of a loved one, or they just know what a last will and testament is. So basically, a last will and testament is a document where the person creating the will, also known as the testator, basically creates rules for how their assets are going to pass after they're gone. And one thing to note is your will only controls assets that are in your name alone when you pass away, that don't have a joint owner and don't name a beneficiary. Because those assets, if you have them, will pass by operation of law, as we just discussed. So if your life insurance policy names your children, if your house is owned jointly with your spouse, and your retirement accounts name your spouse, if you have a will that says you leave everything to your niece won't get anything, because all of your assets are really going to pass by operation of law. But if you do in fact leave assets in your name alone and you leave behind a will, your will control how those assets get distributed at your passing. So two of the important roles, or the main important role that you include in your will, is appointing an executor. And the executor's role is really the person who's in charge after you're gone. And he or she will be in charge of preserving the estate assets, selling things, collecting policies, closing out bank accounts. If you own real property, probably cleaning the house out, getting it ready for sale. And ultimately what they'll do is they'll take your original will with their petition, asking the court to recognize them as the executor, and they'll go to court and seek what's called letters testamentary. And the letters testamentary are what will allow the executor to go to all the banks and to sit at the closing and sell the real property and do whatever is necessary to wrap up the estate. In addition to appointing an executor, your last will and testament also really creates the plan or the terms of how everything is going to get split up. You can do special planning. You can create trust for minors or individuals that may be disabled. So you don't want to leave them out, but you also don't want someone who's on public benefits or services to inherit money from you, because like I mentioned earlier, that could impact their eligibility for those programs. You also may not want your 18-year-old child or grandchild to inherit a substantial amount of money from you for a variety of reasons. Maybe you don't want to impact their financial aid for college, or maybe you just don't think they're mature enough to handle a significant inheritance at the age of 18. So instead, you have the option to create trust for their benefit. So the funds are available should they need it. Should they need things like to pay for tuition or special services or therapy, but because it's not in their name and they don't have control over it, they ultimately will not be able to make the final say-so on how those funds get spent. If you are someone that has means and you're concerned about estate taxes or other types of taxes, you can also do special planning in your will. And it really can be as simple or as complicated as you decide. And a lot of it really depends on the nature of your estate, what type of assets you have, your family structure, your family dynamics. So everybody's, will is very different, and it really depends on what your goals are and what you're hoping to achieve by doing this type of plan. So a question that we get fairly often, at least a couple of times a year in our office, is, my loved one prepared a will themselves. They either hand wrote it or they printed a template offline. Is that okay? In other states, that may be completely fine, but unfortunately, New York State is pretty strict when it comes to the proper execution of a last will and testament. And it's fairly easy to have a will denied probate, meaning the court will refuse to honor it. because it hasn't been executed properly. So some of the basic requirements for what they call a due execution, meaning properly executed last will and testament, is you need at least 2 witnesses that are disinterested. And disinterested basically just means that the witness stands to inherit nothing from the will. So if I'm writing a will and I'm naming my best friend as the executor and she's going to be my primary beneficiary, she should not be one of the witnesses to the will because it's a conflict of interest, basically. In addition to that, the will must also be stapled prior to it being signed. And this also just goes to further proof to the court that pages weren't changed out or inserted, or no one tampered with the will. And what the court is reviewing were the true intentions of the testator, the person who wrote the will. This seems like an obvious requirement, but the testator and the witnesses must sign it in pen. You can't sign it in pencil because that could be erased. And if it is supervised by an attorney, meaning the attorney is the one who not only prepared the document, but also sat with the witnesses and the testator and oversaw the signing and made sure it was done properly, the court gives a presumption that this was done correctly. They assume the attorney knows what he or she was doing, and it'll make it far more difficult for someone to object or to contest the will. And finally, just good standard practice is the will, although it's not really part of the person's document, it's often accompanied by something called a witness affidavit. And the witness affidavit is generally a 1-page document. It's signed by the witnesses, and it's basically just the witnesses attesting to some of the facts and circumstances of the execution. It often says something that the testator was over the age of 18. They appear to read and understand English. They didn't appear to be under any duress. They seem to understand what was going on. And the reason that this is so helpful is if I execute a last will and testament today, and I hopefully don't pass away for a couple of decades, you don't want to have to chase down the witnesses when it's time to probate my will. So the witness affidavit is a way not only to further serve as proof that the person knew what they were doing when they signed their will, it also makes it easier to administer the estate down the road because you don't have to chase down the witnesses. And sometimes it could be difficult. Another reason that it's really useful and important, I would say, to go to not only an attorney, but someone who's familiar with estate planning if you decide to do a last will and testament, is because New York is so strict, if there's ever a challenge to your will, you want to make sure that that attorney has really accurate notes and details and procedures about how that will was signed. If someone presents an objection or a challenge to a last will and testament, and the attorney doesn't have good notes, if they don't remember the testator because so many years have passed, it can make it easier for someone to object to the will, even though the will reflects what the testator truly wanted. So keep in mind, would not recommend doing a last will and testament yourself. And if you have a friend of the family who's a landlord and tenant attorney, it may not be a good idea to use them either, unless there's someone who's familiar and prepares a lot of wills, and executes them as well. So your will actually has no legal effect until you've passed away. And the reason for that is that so long as you're alive and you have the appropriate capacity, you know what you're doing, you can change your will as often as you want. So we'll sometimes have clients or their children that will call the office and say, I'm my father's executor and I want to talk about his estate plan. And if the father is still alive and the father is able to communicate and knows what he wants, it's really not appropriate for us to be talking to that child, even if he or she is named as the executor in the will. Because if the father changes his mind and he decides to do a new will, naming some other family member as his executor, he has every right to do that. So, it happens sometimes circumstances change, people get married, people get divorced, people become estranged, financial circumstances change, someone becomes disabled. At the end of the day, it's a good idea to periodically review your estate plan if you have one in place, because you want to make sure that it reflects your current goals and your current family circumstances. So sometimes we hear about avoiding probate as if it's a really, really horrible thing. And full disclosure, it can be, it can be time consuming. It can become, expensive. And again, depending on the value of your estate, how your assets are titled, what your will says, probate can be a bit of a hassle. But the reason that it's not so terrible in New York is that the probate process itself is fairly straightforward when there's no contest or there's no complicating factor. There are certain states to keep in mind, if you own property in another state, that probate is a really difficult and expensive process just because of the way the estate laws are set up in other states. So Florida, for example, is a state where it's almost designed to make you go back to court multiple times, which results in more attorney's fees and more delays. So if you are a New York resident, but maybe own property in another state, you may want to consider putting some type of plan in place where you're avoiding probate, at least in those other states. And we'll talk about some other ways to avoid probate, but just something to keep in mind. If you own property in multiple states, it could become, more complicated if you're not really leaving behind a solid plan after you're gone. So the last general way that assets pass to others is by a trust. So what is a trust? A trust is basically a legal agreement, and the person creating the trust, just like the person who creates the will, sets out the rules and the terms for how the trust will be administered. And the trust can do a variety of things and achieve a variety of goals. One of the basic goals that it achieves is it provides for how those assets can be managed during the life of the person who created and funded the trust. And either when that person has passed away or at some other specified event, the trust also details how the assets owned by the trust will be distributed and to whom and what percentage. So there are a variety of different types of trusts. A testamentary trust, which we spoke about a bit before. This is a trust that you include in your last will and testament. So you write your will while you're alive, obviously, but any trust that you establish or you include in your will won't actually be set up and funded until after you're gone. So a common example of this may be a testamentary supplemental needs trust. So if you have a loved one that you want to leave a share of your estate to, but they are disabled in some way, it's very common that you would include a supplemental needs trust for the benefit of that individual. So you have funds available to enhance their quality of life, but you're not leaving it to them directly. So they're still eligible for things like home care or Social Security or SSI or Medicaid. A living inter vivos trust. This is a trust that is created by an individual and also funded during their lifetime. So a common example of this type of trust would be a revocable trust. If you've heard of that, it's something that you can create and fund during your lifetime. Again, so the revocable trust is a flexible estate planning tool, and it's attractive to clients for a variety of reasons. The main reason is that they retain control over the asset. They can be their own trustee. They can make changes to it. They can change beneficiaries without needing someone else's permission or input. So that a revocable trust is a type of a living inter vivos trust. And another type of a living inter vivos trust is an irrevocable trust. So an irrevocable trust is similar to a revocable trust in that it's created and funded during your lifetime. It also provides for asset distribution at your passing. The main difference here is that the person creating and funding the trust cannot serve as their own trustee. Irrevocable trusts are done for a variety of reasons. Most commonly, it's created and funded when someone is concerned about long-term care planning. So someone who is maybe concerned that they'll be in need of some type of long-term care in the future, like home care or nursing home care, they create and fund this type of trust for the purpose of shielding some type of asset from creditors, but specifically Medicaid. So a little bit more about the revocable trust. So as I alluded to earlier, this is attractive to clients for a variety of reasons, but primarily because it can be amended and changed at any time. If the person creating the trust, if they later become disabled or sick and they can no longer manage the trust, but they're still alive, they can name a successor or a backup trustee who could step in and just continue to manage the trust property seamlessly without having to go to court or delaying the asset administration in any way. At the death of the trust creator, it provides for what happens to any remaining trust property. Some of the downsides, or one of the downsides, is there's no special, you're not going to avoid any estate taxes if you have a taxable estate. You won't avoid taxes in that way, but, and you also, unfortunately, because you have so much control over the asset, it doesn't offer any protection from your creditors. So if you created a revocable trust and you funded it with an investment account, if you later needed Medicaid, that brokerage account would remain or be considered as available to you because you're as your own trustee, and because you have so much control over how the trust is administered. Medicaid would view that brokerage account as still being available to you and available toward the cost of your care. So that's just something to consider. But one of the main main benefits, rather, is that any asset that is owned by the revocable trust avoids probate. So if you create a revocable trust and you transfer the title to your home, if you own a condo in Florida, if you have some investment accounts, if you have your regular bank accounts, if you go through the steps of properly funding your trust and retitling all these assets in the name of your revocable trust, at your passing, your beneficiaries don't have to go to court. There's no contest. There's no complications. It's a relatively seamless process, and it saves a lot of headache for your beneficiaries down the road. You'll be gone, but whoever you're leaving behind to collect and distribute your assets will have a much easier job because everything is titled in one place, and it has very specific rules for what happens. And if you were perhaps leaving someone out of your estate plan or giving them a smaller share than they maybe otherwise felt entitled to or that they deserved, it makes it harder for those individuals to contest or challenge your plan. So if you're someone that is, has an estranged family member, or just have, some family complication, or there's, some type of, I can't think of an analogy, but if you have, something that would otherwise make your administering your estate a bit more challenging, a revocable trust may be something that you want to consider, just for the, the reasons that I just laid out. So who are the players? What are some of the roles that we just, that are involved when we're talking about a revocable trust? The settlor. The settlor is the one who creates the trust. They're the ones who fund the trust, and very often they're also the person who's initially in charge of running or managing the trust. The trustee. So the trustee's role in all trusts is to basically manage the assets and to follow the terms of the trust. In this case, it's fairly easy because the person who wrote the trust or created it is also going to be the one who's in charge of managing it and following its rules. So this one is fairly straightforward. And then finally, the beneficiary. So this could be two different types of beneficiaries. This could be the beneficiary of trust income or principal while the settlor is still alive. So very often that will be the settlor themselves. But the settlor can also say, if I become disabled, I direct my successor trustee to make the income and principal available for the benefit of my spouse or children. Once the settlor has passed away and the trust is to be terminated and distributed, the trust document also includes after death beneficiaries. So who's going to get the remaining trust property and in what percentage. And just like with a will, you also have the option to direct individual shares to be held in further trust. Again, this is very useful when someone is a minor or has some, maybe a creditor issue or a disability. So this, I cannot stress this enough. In order to be effective and in order to have any legal effect, your trust must be funded. One of the most frustrating conversations to have is, or heartbreaking rather, is meeting with a family who has, coming to you because some crisis has happened and they're coming to you and they think that they have a good estate plan in place. They'll say, oh, my mom or dad, they did a trust 7 years ago, everything's good. And you're reviewing the trust document with them, but they have no idea what the trust owns. And you're looking at their bank statements, and all their bank statements reflect that mom and dad still own these assets outright. And they've gone through the expense and the time to create a trust with an attorney, but they never took the next step, and the trust doesn't actually own anything. So creating the trust itself is important, but an even more critical step is making sure that you take the time to go to the bank, retitle your bank accounts, retitle your home, if that's what you're planning on putting in there. One thing that you're not going to put in there is your retirement accounts. So your house. Your house is a really easy thing to fund with the trust. You retitle it by creating a new deed and executing it. It gets recorded in the county where the property is located, and then that's it. You don't have to do anything else. You continue to get your same real estate tax exemptions. You continue to pay the bills, the maintenance, the taxes. But at your passing, the house will go to your beneficiaries automatically. Bank accounts. So annoying because you have to make the extra step if you're someone who has a lot of bank accounts in different banks and passbooks and CDs. It's certainly time consuming, but it's well worth the effort when everything is combined into one place. And you know that if you became disabled or you became unable to manage these things, everything is named in one place, and one person will have, or two people will have the control and the ability to manage these in the event of your disability. Brokerage accounts or other investment accounts, mutual funds, individual stocks or bonds. You really can put most assets into a revocable trust. Before I move on here, I do want to make a note that regardless of the type of trust that you either have or may have in the future or you're considering, you never want to retitle any qualified or retirement accounts in the name of a trust. So if you have a tax-deferred annuity, a 403B account, a 401k, a traditional IRA, those are assets that you should always leave titled in your name alone. The reason for that is if you have a qualified account and you transfer that account into something like a revocable trust, that's considered a taxable event because you're making a change to how that account is titled. And what you'll basically be doing is making all of the income tax that you've been avoiding while the account grows become due. So before retitling any assets, always check with your accountant or financial advisor or attorney if you're unsure of the nature of that account. So rather than using a retirement account to fund a trust, what you should be doing is making sure that that account has at least one primary beneficiary, and to be really secure, making sure it also has a contingent or a backup beneficiary, because you don't want to leave those types of accounts with no beneficiaries. It just makes it harder to administer your estate. So I've kind of touched on a few of these points already, but a few different scenarios or when it may be a good idea to consider doing a revocable trust. So again, if you're concerned about who's going to manage my affairs if I become disabled, the revocable trust is, a good planning tool, because you can, once it's funded, you can continue to handle your affairs. But if you become sick or becomes too much, you can have someone that you trust kind of take over and step in when you're unable to do so. I've mentioned this before, but if you're someone who owns a lot of real property, some people have, multiple pieces of property in New York. They have a vacation home or rental property, especially if you own property in more than one state. Essentially what happens is if you're leaving multiple pieces of property in different states, really what you have to do is start a probate proceeding in each of those different states, if you don't have something passing by operation of law or by a trust. So that's something to definitely consider. If you're concerned about a will contest. So this is especially important if you're single, if you don't have children, and maybe you're leaving your estate to, 2 out of your 15 nieces and nephews. Just be aware that if that's what your estate plan looks like, when you pass and your 2 nieces and nephews that are set to be the beneficiaries, when they go to court and present your will, your other 13 nieces and nephews are going to have an opportunity to come forward and contest that. If you decide that one of your children is really irresponsible with money and his or her share is going to be held in trust, you can put that in your will, but your child then has an opportunity to come forward and contest that. And doesn't mean they'll be successful, but what it does mean is that they have an opportunity to be heard, and it could delay the court issuing letters testamentary to your executor. And if you have to collect assets, if you have to pay bills, this can just be, make it more stressful for the executor and the other beneficiaries. When there are missing heirs. So this doesn't happen all that often, but everyone's family situation is different. If you are someone that has a family member that would, that they're unknown and you can't find them, this is something that you really should consider. Essentially what happens when you probate a will is, this is going to sound strange, but when you probate your will and it says, I leave everything to my cousin, what New York State requires is they say, who would be entitled to be notified if this person didn't have a will? So if we were distributing this estate under the laws of intestacy, the decedent, who are their distributees? Who are their heirs at law? So even if these people are not named in your will, they're still entitled to notice. And if you have never spoken to your mom's side of the family or your dad's side of the family, or there's that cousin that just up and vanished after college and no one has seen her since, this is something to really consider, because if you're relying on your will and you have this kind of strange family situation, if you're relying on your will to distribute assets at your passing, just know that your beneficiaries may have a hard time, and it may delay the proceedings. Again, not common and may not apply to you, but just something to be aware of. And again, I've keep mentioning this, but if you're concerned about probate for whatever reason, or you just want to make it easier for your beneficiaries to collect your property at your passing, avoiding probate, maybe for some people that's the main reason that they do a revocable trust, is their family gets along fine, they have no wacky circumstances, no one's disabled, no one's a minor, but they really just want to make it easy and seamless for their kids or their loved ones. So their main goal is just avoiding probate. So I'm going to talk a little bit about estate taxes. So for the average person living in New York State, they don't have to worry about estate taxes, because if the value of your estate, so when you total up everything that you leave behind, whether it's passing through a trust, under a will, through intestacy, by operation of law, if you total all of those assets up and it's below $5.85 million in New York, you don't have a taxable estate. Anything over and above that, you may be looking, you'll potentially owe some estate taxes, and that's a nice problem to have. If we're looking at the federal government, it's even more than that, and it's just under $1.6 million. If you're married, you can double that by passing more to your spouse tax-free. But something to be aware of, these are what the current rules are right now. So when we meet with clients, we always like to note that, it was less than 10 years ago that the New York State exemption was $1 million. And people still laugh or kind of say, I'm not a millionaire, that's not me. But if you live on Long Island and you own a home and you have some retirement accounts and savings, it was far more common for people to have a taxable estate. So although the exemptions are fairly high right now, they're set to sunset or expire in 2026, a couple of years from now. So we don't know what that's going to look like. We don't know if there's going to be a change, if it's going to stay the same, go up, be reduced back down closer to $1 million. And a lot of that really depends on the administration at the time the estate tax laws are set to expire. So although you may have nowhere near a taxable estate now, it's never a bad idea to, consider it, have some plan in place, because you don't know what's going to be in effect when you pass away, because unfortunately nobody has a crystal ball. We don't know when that's going to happen, but I do just want to mention that. So all these taxes, estate tax changes took place a number of years ago, and the estate tax exemption has been creeping up every year. But one thing to be aware of is capital gains tax. So this is something separate and apart from your income taxes, separate and apart from any estate taxes that may be owed by your estate when you pass away. Capital gains tax is basically a tax on a gain. So if you bought a piece of property in 1990 for $50,000 and you sold it today in 2021 for $500,000, the potential gain that may be taxed is the difference between your purchase price and any improvements you made on that property and what you sold it for. So this applies not only to real property, but also things like stock, bonds. So if you bought, you work for Verizon 20 years ago and you got some stock, you paid nothing for it. It was part of some package you got at work, and your basis is zero, and now the stock is worth $200 a share. You were to sell the property or the stock today, you could be looking at some capital gains taxes. So this is just something to be aware of if you have owned or held on to an asset for a long time and you're thinking about transferring it or selling it. Just always something that you should have in the back of your mind, that capital gains taxes may be something that you have to deal with if you sell or transfer that asset. So again, not something that most individuals have to consider because they don't have a taxable estate, but some ways to reduce a taxable estate if you do in fact have one. You can make an unlimited amount of $15,000 a year gifts to people. So if you are someone that's on the cusp, or someone is on the cusp, and they want to avoid estate taxes because they don't want to pay the government more than they have to, they could give a gift of $15,000 to everyone in their family and their mailman and their hairdresser, and they'll owe no taxes. What they'll have to do if the gifts exceed $15,000 is they're technically supposed to file a gift tax return with their as a separate return when they file their income taxes. Generally, no tax will be due, but it's something that you're supposed to file. Another way to reduce your taxable estate, if that's a concern, is not gifting the money to someone, but if you directly pay for a medical or an educational expense on behalf of anybody, that's another way. That's a way to reduce your potential estate tax liability. So there is no cap on this. So if you have 3 grandchildren and they're smart enough and they all get into Harvard and you're really generous and you pay all their tuition, there's no cap on that, so long as you pay the institution or the hospital or the doctor directly. And you can make an unlimited amount of gifts to your spouse, either during life or at your passing, and there's no tax imposed for these gifts either. So one concept that I do want to mention, again, this is not something that is as widely used today, just because the estate tax exemption has gone up significantly. But when the estate tax exemption in New York was only $1 million, this was something that we routinely included in our last will and testaments to give spouses flexibility. So a credit shelter trust is basically a way to increase what you as a married couple ultimately pass on to the next generation tax-free. So if John and Mary each have, just over $5.4 million in their names, they're very lucky and they've done very well for themselves. But without planning, they can really miss an opportunity to save themselves or save their estate or their children a lot of taxes. So if John predeceases Mary and he does no tax planning, he doesn't have a will, he misses the opportunity to pass $5.4 million to Mary tax-free. So what does that mean? If instead John and Mary both create last will and testaments with credit shelter language in there, it basically just means that $5.4 million, rather than going to the spouse directly, is held in trust for the benefit of the spouse. And while the surviving spouse is alive, the income in principle is available for his or her benefit. And at their passing, the remaining funds pass tax-free to their children. So this is a very roundabout way of saying, even if you think you may have no estate taxes due at your passing, again, we don't know what the estate tax rules are going to be. Your assets may change, your circumstances may change. So it's just something to consider if you're thinking about doing a last will and testament. So we kind of covered, the 4 basic ways that you pass property or assets to your loved ones. And for those of you who joined me 2 weeks ago when we talked about the elder law or discussed the elder law workshop, just going to circle back and just touch on it for those individuals that weren't able to join us. So we're going to talk a little bit about, what happens, you haven't passed away, but something happens. You either become sick or you have an accident and you're suffering from some type of disability. So we're going to touch a little bit on surrogate healthcare decision-making. So again, for those of you who joined me 2 weeks ago, if you have any questions or if this is repetitive, I apologize, but I did just want to touch on it since we have some time. So these are the basic ways that a third party can make a medical decision on your behalf if you're unable to. So the most common way is something called a healthcare proxy, which I encourage all adults to have. If you don't have a healthcare proxy, please email me and I will send you a blank form with instructions on how to do it at no charge. It's really important that every adult have one. So a healthcare proxy is basically a document where you can appoint one primary and one backup agent to make medical decisions on your behalf if a doctor has determined that you're unable to. So this is important because you may not be married, you may not have children, or maybe you are, but you don't think that person can emotionally handle making those decisions. So you'd really prefer to have your best friend step in and do that because he or she really knows what you want. You could pick anybody that you want. It's, gives you an opportunity to appoint someone that you know well and that you trust and will carry out your wishes. A living will is often a document that accompanies a healthcare proxy. So in a living will, you're not naming an agent. Instead, you are listing instructions or preferences for various medical procedures or services. And it basically tries to anticipate different medical scenarios in the future. And in that document, you list what you want or don't want if you find yourself in that particular type of situation. So it's really more a set of instructions for anyone who's acting on your behalf. In the absence of a healthcare proxy, if you find yourself in a hospital or some other medical facility the Family Healthcare Decisions Act in New York State will take over. So just like the laws of intestacy, the Family Healthcare Decisions Act basically creates a list of people or a hierarchy of people who can make decisions on your behalf if you're unable to. And it just goes, spouse, children, parents, siblings, and further down the list to more remote relatives. So this is a nice safety net for someone who doesn't have any plan in place and something catastrophic happens and they find themselves in a hospital. If they can't in some way make their wishes known, but they have a trusted loved one, that person can step in and communicate and make decisions on their behalf. So where this becomes complicated is if you don't have a family or you don't have someone that you trust. It also becomes complicated if you have 3 kids and your 3 kids can't come to some decision and something needs to be decided on an emergency basis. It can become complicated. So again, if you don't have a healthcare proxy, please email me and I will send you one and you'll get it done and stick it in your wallet with your insurance cards. You make a bunch of copies, give them to your doctor, and you will avoid needing to rely on the Family Healthcare Decisions Act. A MOLST form stands for Medical Orders for Life-Sustaining Treatment. It's a bright pink form. So the MOLST and the DNR, which is a Do Not Resuscitate order, they're not documents that you would go to an attorney to have prepared. Those are typically documents that are done in a healthcare setting after you've spoken with a doctor or a social worker. It's typically when you're, unfortunately not doing well health-wise, and it's really just listing out, some of the different end-of-life decisions that you, or treatment rather, that you want or don't want. So making surrogate financial decisions on behalf of somebody else. There's a couple of different ways that these take place. The most common way, and I'm sure a lot of you have heard of the power of attorney. So a power of attorney is a document just like a healthcare proxy where you appoint at least one person. You could have 2, you can have a backup to make financial decisions on your behalf. And a power of attorney can be as narrow or as broad as you want it to be. If you have people in your life that you trust, it's often not a bad idea. It's really a lifesaver if something happens in an emergency. But a power of attorney, if it's done properly, can allow your agent to do things like Medicaid planning, creating and funding trusts, dealing with your insurance companies, dealing with all of the things that you deal with on a daily basis that don't involve making a medical decision. And if you truly became disabled in some way or incapacitated, a power of attorney is a really incredibly helpful tool for your family or loved ones to have. As we discussed before, revocable trust. So if you already created and funded your revocable trust and all of your assets are titled in there, if you became disabled, your successor trustee could step up and then just seamlessly take over paying your bills, dealing with your house, managing your assets, without needing to go to court or rely on any other document. And unfortunately, if you don't have any plan in place and you unexpectedly become disabled and you can't pay your bills, no one has access to your accounts, then someone in your life is looking at a guardianship proceeding. And a guardianship proceeding it's a court proceeding where someone is filing a petition and they're alleging that you can't manage at least some aspect of your life, whether it's making medical decisions, paying your bills, dealing with your property. And it's a court proceeding, so it's lengthy, it's time consuming, it can become expensive, but more importantly, it's public record. So now your disability is out in the open, some of your financial information. The court does take great pains to protect your privacy as much as possible, but you're getting the court involved in your life where someone on your behalf is. So as someone who does guardianships as part of her job, I would really strongly advise you to consider just doing some basic planning documents to avoid them, because they're not fun for anybody that's involved. So I'll leave you with that. Plan. So I hope everyone enjoyed today's. I'm going to take some questions if there are any, but again, I'm just going to leave my email on there. If you don't have a healthcare proxy, if you didn't get the handouts, if you have any questions, please feel free to reach out to me and to ask any questions that you have. I'd be happy to answer them. I know I just threw a lot of information at you, and sometimes you need to hear it a few times in order for it to make sense. So let's see, I think I have, so I had a couple of questions here. If I had a Roth IRA, would it pass to my kids with a transfer on death? It could. So the important thing is, for not just a Roth IRA, but for any account that you have, is you should really routinely check your beneficiary designations. So if you're unsure, then you should check. Because if you haven't actually taken the steps to name beneficiaries, whether it's a Roth IRA, a savings account, a CD, a 401k, a life insurance policy, the financial institution has no way of knowing who your relatives are or where you want that assets to go if you don't tell them. So people often will assume that they did it when they established the account. Sometimes they haven't. So it's always a good idea to periodically check. So that's a good question. Thanks for asking that. And then someone asked, do heirs at law have a right to your trust? So it will depend on what the terms of your trust say. So an heir at law is basically who would inherit from your estate if you had no estate planning documents in place, meaning who are your distributees is what the court will describe it. So a distributee is basically who is going to inherit from me if I have no will. And your heirs at law, the same thing as a distributee. And they may inherit from your trust, but who's going to inherit from your trust is the people that you name in the document as a beneficiary. So if you have 3 children and you name them as equal beneficiaries to your trust, then those are the individuals that are going to inherit from your trust. I hope that answers your question. If it doesn't, please feel free to ask a follow-up. A really good question here. So what do I do with the healthcare proxy? Do I give a copy to my doctor to put in file? It's a great idea. One of the nice things about a healthcare proxy is it's one of the few legal documents where a copy is just as good as an original. So we often encourage clients to make as many copies as you need, give copies to your agent and your backup agent. Not a bad idea to make a copy, fold it up, and leave it with your insurance card. So if, I hate to sound doom and gloom, but if God forbid you're in an accident and you have to go to the hospital, if you're by yourself, you know, the hospital will often look in your wallet to determine who you are. So if they see a healthcare proxy, they'll at least know who to call in an emergency. But that's a good question. I think there's a, so this is a good, another question. So somebody asked, if I choose not to leave my assets equally to my children, what type of issues can I expect later on, even if I put a clause in there saying if they contest, they only get $100. So those types of clauses are sometimes referred to as interorum clauses, which is, they're basically clauses that are meant to deter people from trying to challenge them. So even if you include those clauses in your will, they're still allowed to show up and ask some preliminary questions without triggering that clause. So if you, for whatever reason, don't want to leave your estate in equal shares to your children, basically what that looks like is when you're gone, hopefully not anytime soon, when you're gone, whoever you've named as your executor will submit your will to court. This is known as a probate proceeding. And what that means is your beneficiaries and your executor are asking the court to approve your will and issue the letters testamentary. So this child that you may be leaving a smaller share to, or you know, your the $100 share, they're going to be entitled to notice. And when they get their notice, they get a copy of the will. So they're going to see that they're getting, you know, perhaps a significantly smaller share than their siblings. And they basically have the option to show up and indicate to the court that they have some questions about the will. And without triggering that clause that would leave them only $100, the court allows them to basically depose the attorney, the drafting attorney, the witnesses, and what they're looking for is, was my mom or dad unduly influenced by my siblings? Did they have the capacity? This doesn't mean they're going to be successful, but it does potentially delay the proceedings and kind of hold things up. And depending on the county where you live, I'm assuming Nassau, sometimes the courts are acting or operating on a pretty slow basis to begin with. So it may not be the end of the world, and it may be something that you're willing to let your beneficiaries deal with, but just something to be aware of. I will say that when a will is prepared and executed under the supervision of an attorney, and the attorney does what they're supposed to do, it's fairly difficult to have that will invalidated or overturned. You have to, someone objecting to the will has to demonstrate that the will is invalid for only one of a few reasons. And it can't just be, my mom is leaving me less than my brother and sister. The person objecting to the will typically has to demonstrate that the testator, the person who created the will, either lacked the capacity to sign the document when they did. Maybe they had Alzheimer's or dementia, or they have to demonstrate that they were unduly influenced, meaning, one sibling was in their ear and was really persuasive and took them to the attorney and sat in all the meetings and made the appointments. Another grounds for invalidating a will is because the will was done under duress. So one of your kids saying, "Mom, I'm not going to feed you unless you sign this will that leaves nothing to my brother." Or finally, fraud. So you slip someone a piece of paper and you say, "Hi, you're signing your a check for your light bill," and you're really signing a will that disinherits one of your kids. So just because someone has an opportunity to challenge your will doesn't mean they'll be successful. But if it goes into full-blown litigation, just like any other court proceeding, it can drag on for a long time. It could, make it messier between your surviving heirs if it's not already messy. So sometimes what we recommend to clients, if you don't want to do a trust, another option that you have is maybe you have a will that leaves everything equally to your children, but you use beneficiary designations to take care of most of your assets. So if you have 3 kids and you want 2 of them to inherit the bulk of your estate for reasons known to yourself, you can name those 2 children as beneficiaries on your retirement account, your life insurance, investment accounts that you may have. And then maybe you have a will that says, "I leave everything else equally to my 3 children," which could really be nothing. But a lot of it will really depend on the nature of your assets, your other goals, the rest of your family dynamic. But it's a good question. I don't see any other questions coming in. Let me just make sure I'm not missing anything. Oh, I think I just missed one here. I think that's it. Again, my name is Deirdre Baker. I hope you learned something today. I hope I didn't throw too much information at you. My contact information, I emailed everybody yesterday. If you have a question you didn't feel like answering on the chat, or you forget and you remember it in the middle of the night, like I often do, please feel free to reach me at the office or email me. If you didn't get the handouts, or if you have any other information that you'd like, please feel free to think of us as a resource. It's been a pleasure, and stay safe, everybody. Take care.